You know that feeling, right? You sign on the dotted line for a new phone, a job, whatever it is, and then that little knot of regret starts to form in your stomach. But what if that feeling isn't just buyer's remorse? What if the deal itself was actually broken from the very start? Today, we are diving into the legal trapdoors that can make a supposedly binding contract completely fall apart. Yeah, that feeling of being pressured or that sinking realization you weren't told the whole story, it's not just uncomfortable, it's a huge legal red flag. And it makes you wonder, if you didn't really agree freely, did you agree at all? Well, the law has a very specific answer to that.
And that answer brings us to the absolute bedrock of every single valid contract: free consent. Legally speaking, an agreement is only solid if everyone involved says yes without being pushed, without being deceived, and without some kind of massive misunderstanding. Think of it as the gold standard for any deal.
But what happens when that foundation isn't so solid? Well, we're about to look at the 5 critical flaws, the cracks, if you will, that can cause an entire contract to just crumble. Let's dig into them one by one. Okay, first up, let's talk about those deals where your consent isn't really given, it's pretty much taken from you. This happens when one side uses some serious pressure or abuses a position of trust to get their way.
So you've got 2 different flavors of pressure here. Coercion is like the sledgehammer. It's brute force. It's open threats of doing something illegal to get you to sign. But undue influence, that's more like a scalpel. It's that subtle, manipulative pressure that someone in a position of power or trust can use against you.
And listen, coercion isn't always about threatening physical harm. The law is super clear on this. Threatening to commit any act forbidden by the penal code to force a signature counts. So this example right here, threatening suicide to pressure someone into a contract, that is a textbook case of coercion. That consent was not given freely, which means that contract is built on some seriously shaky ground. Now, for undue influence, just think about a doctor and a patient. I mean, a patient is vulnerable, they trust their doctor completely. If that doctor turns around and uses that trust to push for a ridiculously high fee, they have crossed a major legal line. And that's exactly why the law steps in to protect the person in the weaker position from that kind of exploitation. So that's what happens when you're pressured into a deal. But what if the problem isn't pressure? What if the problem is that you've just been lied to? Our next category covers contracts that are built on a foundation of pure deception.
The big difference here, really, it all comes down to intent. Fraud is a deliberate lie. It's an act specifically designed to trick someone into signing. Misrepresentation, on the other hand, is an unintentional lie. It's when you make a false statement that you honestly believe is true. One is malicious, the other is a mistake. But guess what? Both can be absolutely fatal to a contract.
And fraud is so much more than just telling a straight-up lie. It can be actively hiding something important, like painting over a huge crack on the wall before you sell a house. It can be making this grand promise that you have absolutely zero intention of ever keeping. Basically, any act that's fitted to deceive someone into a deal, that can be considered fraud.
And here's a real-world case that just nails this point. A construction company took money, took deposits for way more apartments than they were even building. They made a promise to all those buyers knowing full well they could never keep it. And you know what? The court saw this for exactly what it was, a clear-cut case of fraud.
But remember, the deception doesn't always have to be malicious. Just imagine someone is selling their motorcycle, and they proudly claim, oh yeah, it gets 50 kilometers per liter. They genuinely believe it's true, but they've never actually checked the numbers. When the new owner finds out it's way less efficient, there was no intentional lie, but the deal was still based on false information. That's misrepresentation.
All right, finally, we get to this really fascinating scenario where, get this, nobody is at fault. There's no pressure, there's no deception, there's just a massive, fundamental misunderstanding that's shared by everybody involved.
So to see how this works, let's just imagine a simple scenario. Okay, person A agrees to buy a very specific house from person B. They shake on it, they sign the papers, the deal is done. On the surface, it looks like a perfect, straightforward contract. But there's a huge problem that neither of them knows about. An hour before they signed that paper, the house was completely destroyed in a fire. Since both of them were mistaken about the very existence of the thing they were making a deal about, the agreement is totally void. It's not just broken, it's like it never even happened.
So if a contract is based on coercion or fraud or one of these mutual mistakes, what actually happens next? What are the legal consequences when that whole foundation of free consent is just gone?
This is where it gets really interesting, because the outcomes are very specific. In cases of coercion, undue influence, fraud, or misrepresentation, the contract is what we call voidable. This gives all the power to the person who was wronged. They get to choose, either cancel the whole deal or go ahead and enforce it. But with a mutual mistake about a key fact, the contract is just void. There's no choice to be made. Legally, it's a total nothing from the very beginning.
Oof. Okay, we've just walked through the 5 big minefields that can totally blow up a contract. So what does all this mean for you? How can you actually use this information to protect yourself and make sure your agreements are rock solid?
Honestly, it all boils down to one simple but really powerful principle: free consent. For a deal to be strong, for it to actually be binding, you need a genuine meeting of the minds. No force, no lies, and no critical errors. Knowing about these 5 flaws isn't just a boring legal theory. It's your first line of defense. It's your essential toolkit for every single deal you make.
And I'll just leave you with this question to chew on. In today's world where we're all clicking "I agree" on terms and conditions we've barely even looked at, which of these flaws, from a subtle misrepresentation to a carefully hidden clause, do you think is the biggest risk we face? It's something to think about the next time you're about to make a deal with a single click.